The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 4 cases will be submitted this morning. These cases are Stephen Mueller and others versus Wellmark, Inc., State of Iowa versus Mario Guerrero Dodaro, State of Iowa versus Max Thorndike, and State of Iowa versus Warren Lovell. The last 2 cases will be submitted without argument, and we'll now hear the arguments in the first case, Mueller versus Wellmark. Mr. Norris.
Thank you, Your Honor. May it please the Court. We claim, I represent chiropractors, Iowa chiropractors, we claim that it's a per se violation of Section 553.4 for Wellmark to enter into agreements with competitors to set the maximum price for services of plaintiffs by selling or renting out the use of the Wellmark provider network, and in particular plaintiffs' provider contracts with Wellmark, to self-funded employers and out-of-state blues, both categories of which are competitors or potential competitors for the purchase of plaintiffs' health care services. This issue was not addressed in the district court's ruling. Wellmark defines the issue in this case as courts will not condemn a cooperative business agreement as a per se violation of the antitrust laws unless judicial experience shows that the agreement lacks any redeeming value, that it is always or almost always anti-competitive. This issue was not addressed in the district court's ruling either. The district court, in the proceedings after remand from this court, seemed to be focused on whether or not the price set by Wellmark was reasonable. The price was reasonable. That's why the court indicated that it was inclined to stay all proceedings unless the issue was per se only while the case before the insurance commissioner was pending. The court's final order focused on the need for rule of reason analysis of Wellmark's, and I'm quoting, setting provider prices in its preferred provider agreement. That was not the issue. It's never been the issue in this case. The Supreme Court of the United States cases are clear that the reasonableness of price is never the issue in a horizontal price setting case.
You would agree, Mr. Norris, the market power, assuming Wellmark has market power, is not relevant either, right?
It wouldn't be as far as if it's a per se case, but I think the way the cases are coming out in the United States Supreme Court, it is arguable that the decision as to whether or not the industry is susceptible to per se or qualifies for the per se case, you have to have all this stuff before you to at least take a look at it.
But if it's a per se violation, it would be illegal even if United Healthcare or Coventry or someone who had a very small percentage of the health insurance market did the same thing. That is, agreed to
I agree.
Provide.
There's only one case I know of where that doesn't seem to have been the case, and that's Appalachian Coals. But that was a peculiar situation. Of course, Saucony Vacuum Oil does indeed say that, as does Arizona versus Maricopa County, et cetera, et cetera. It has been the case since 1898 or 1897 in Trans-Missouri Freight that the court has always rejected the idea that the reasonableness has to be, or analysis has to be in the reasonableness of the price. That is not the issue. The issue is always, is the combination, contract, or conspiracy in restraint of trade is that reasonable or not? Is it reasonable for some people to come together and enter into a collusive market, price fixing, and that has always been, the answer to that has always been no, it is not reasonable.
Counsel, to what extent do the Iowa insurance statutes and regulations encourage organizations like Wellmark to enter into provider agreements and networks of this kind?
Well, that you're talking about 514F.2, certainly they got permission in HF 2219 to do that, so long as they don't discriminate against chiropractors. But that issue is before the district court right now. We're through the insurance commissioner, and hopefully next year we'll see you on that one. But as far as the encouragement, I mean, we've already dealt with the whole idea of state action and whether there's state action or not.
We rejected that defense, of course, in the first appeal in this case, but isn't there some tension between the idea that one statute will in effect bless this type of arrangement that your group of plaintiffs is contending is per se illegal as a matter of law, automatically can't do it?
Going to the actual definition in the insurance rules, a preferred provider arrangement, if that's what we're talking about, which is encouraged, that is a contract between the healthcare insurer and the provider. Now that, I mean, we're not at all talking about that being illegal. We've all entered into those contracts. What we're talking about is taking the existing network, which in Wellmark's case has been in place since the 1940s, takes the existing network and sell it or rent it to potential competitors.
You talk about competitors. Let me kind of play this out. When I was in private practice and we had cases together and you generally won.
No, we did not generally.
Anyway, when I was on the management committee of the law firm, we would put our health insurance out to bid every year. And we had two different options. We had different health insurance companies we could look to. And we also had the option of either buying claims administration services and financial protection from the insurance company, or claims administration services and self-insure, assume the risk ourselves. Now, why isn't it actually pro-competitive for a consumer like my former law firm to have those kinds of more choices? Doesn't the fact that it's potentially pro-consumer mean that we shouldn't apply a per se analysis? We should require you to prove up a rule of reason case where you have to show actual anti-competitive
Your Honor,
effects.
respectfully, and I remember your questions the last time on this issue, and I put a whole section in the brief showing why it is anti-competitive and why it restricts output. But what you're talking about again is why can't we have a choice of several different options as far as to whether we become self-funded with an administrator or whatever. Well, I don't have any problem with that either. I don't have any problem with you becoming self-funded and having an administrator as long as that administrator is not a competitor or a potential competitor. The problem here isn't the administrator. The problem is that the central issue in this combination that we're talking about is they want to get a hold of Wellmark's provider network, but in particular they want to use Wellmark's prices. And in our case, they're highly discriminatory. Now, I will say that in Iowa generally, you've got a bilateral monopoly between Wellmark and, say, Unity and Mercy particularly, who have all the hospitals and all of the practitioners, MDs, DOs, nursing practitioners, physician's assistants, all those people. You've got countervailing power there, and they probably fare pretty well. But our people are either sole practitioners or are in small groups. They don't have a blanket protector like Unity Point or Mercy, and as a consequence, this has a very detrimental effect to them as far as market. They face this Wellmark market, no matter whether they're talking about health insurance, PPO insurance, or the self-fundeds.
I mean, nothing prevents you from coming in and proving these anti-competitive effects and proving that Wellmark has market power and so forth. The issue is, are we going to say that these arrangements are automatically illegal, right?
The answer is yes. You should say they're automatically illegal because there isn't any recognized exception for insurance companies getting together, other than in terms of the McCarran-Ferguson Act. And this, we're not talking about that here. We're talking about purchasing, all right? And there isn't an exception for professionals as far as rule of reason is concerned in a price-fixing situation. There has never been such a thing. Wellmark's is not a cooperative business arrangement. A co-op is some entity or whatever that sells or purchases for members in a different level of distribution. We're talking about here Wellmark that is in the same level of distribution, or purchasing in this case, same level of purchasing as all of these self-fundeds that it is allowing to use its network. Now, just common sense says that that's a price fix by competitors. As a matter of fact, Wellmark asserts, and then this is seems to be the pro-competitive idea that they assert. Wellmark says that without their ability to use our pricing, the self-funded is not feasible for most people. Well, I mean, that isn't the only option available to a employer as far as buying insurance or providing insurance for its employees. You know, there are other ways to do it. You can buy a state insurance contract for one thing, and the next thing is you could form your own PPO group among the self-fundeds, so long as the self-fundeds weren't in control of it. But the pernicious thing here is that Wellmark has a huge batch of the insurance business in group, individual, and large group to begin with. And then it's compounded by the fact that half of its members, this is in their affidavits, half of its members are in the self-fundeds that they bring in on top of that large market share. So you're talking about probably, just eyeballing things, you're talking about maybe 60 or more % of the entire health insurance product that isn't Medicare or Medicaid, and that's a huge bunch, but that isn't Medicare or Medicaid. 60% of that now is controlled by Wellmark, and that's what my clients are faced in trying to provide services to the patients.
Counsel, you began by arguing that the district court didn't answer the right question. Did you do I still want to call them Rule 179B motion, but a 1.9042 motion to seek, to address any issue that was left on the table?
Well, the court did rule. The court did rule on their motion. All I'm saying is that the court defined the situation in its ruling. I mean, it was in the motion, Wellmark raised that this isn't a per se violation. All right, the court holds that it isn't a per se violation, but it does it in terms of saying you have to use the rule of reason to look at preferred provider contracts. Well, I don't know that a preferred provider contract is a violation of antitrust laws at all. Thank you very much.
Thank you as well, Counsel. Mr. Koopmans.
Thank you, Chief Justice. May it please the court. The per se rule of antitrust liability does not apply unless, based upon significant judicial experience, the courts know that this business arrangement has no redeeming value or almost no redeeming value. That does not apply to the agreements in this case. Wellmark does indeed share its provider network with its self-funded customers. It acts as a plan administrator, and it also shares its provider network with out-of-state Blues, just as Wellmark gets to use the out-of-state Blues network, essentially creating a national insurance company. That is not the type of agreement that the courts have said has no redeeming value, that is per se unlawful. Indeed, it does have pro-competitive justifications. If we take a step back for a second, too, the business arrangement here fails on the first prong, I guess, if you might say, judicial experience. The courts have almost no judicial experience, at least saying that these kinds of agreements are anti-competitive or always anti-competitive. The only case in which we could find in which this type of arrangement was addressed was the North Jackson Pharmacy versus Caremark case, in which the district court there, the federal district court, went through quite painstakingly, I think, analyzed the U.S. Supreme Court precedents on the per se rule versus the rule of reason, and decided that indeed the rule of reason applies. Also, I think it's worth noting that this, as we've cited in our brief, this type of arrangement in which a plan administrator provides a network, a provider network for several self-funded plans, it is a common practice across the United States, and in fact, it is a more common practice in Iowa than in other states. The evidence that Mr. Norris submitted, which is at page 733 of the appendix, states that Iowa, more than any other state, many other states, has a lot of self-funded customers, and indeed, the Affordable Care Act is going to only increase that because of the incentives have created greater savings if you self-fund. If plaintiffs are correct, if this is indeed a violation for any payer of healthcare service to share a provider network, then no one can share a provider network. That means almost no employers will be able to self-fund. They do not have the economies of scale to go out and find out what doctors are willing to pay, set those price schedules, make those claims, do the credentialing, make sure these doctors have the capability to provide the types of services that they do. Self-funded plans will largely cease to exist. That's not to mention the fact that these would be criminal violations, per se price fixing. We're going back how many years, and all of these self-funded plans, according to plaintiffs, even though those self-funded plans have not been sued in this case, they have committed a per se violation of the antitrust laws and are subject to treble damages. Obviously, without having to prove that this arrangement actually harms competition in any way, that is a significant thing that the antitrust laws are not designed to do. It's also worth noting that the antitrust enforcement agencies are very aware that self-funded plans share provider networks all the time. They think it's just fine. In fact, the ability to self-fund, Justice Mansfield, does provide greater competition in the market for health insurance. If an employer feels that an insurance company has set the risk premium too high for their particular employer, I mean, obviously, an employer knows its employees better than the insurance company does. It has the ability to self-fund, and that can indeed keep insurance companies in check. If sharing a provider network is per se unlawful, then no one can do that, and exactly what Mr. Norris said is going to happen. They're probably going to have to buy insurance, which just means that this, quote, monopsony power that Mr. Norris keeps talking about is just going to be brought into the insurance context instead of done by self-funded plans. There will be no difference as far as the providers are concerned. Instead of Wellmark coming to the provider and saying, we have this many insured lives in self-funded plans and our insurance plans, they will just have them all in insurance. That doesn't help providers any. It certainly does not help Iowans who are buying health insurance. It will only increase the cost, most likely. The arrangements here, going back to kind of the framework for how you analyze them, are what you would call an ancillary restraint, meaning that they have pro-competitive justifications beyond just the setting of prices. The PPO product in which we're talking about, the preferred provider organization product, the very point is to allow insureds to go to the doctor and know exactly what they're getting into beforehand. The health insurance market, or the health care market, I should say, is not your typical competitive market. There is no sign outside the doctor's office that says, on sale here today, visits $80. Patients don't know how much they're going to pay, most likely, until they show up. And that is the beauty of the preferred provider organization, and that's why it is the top insurance product out there today, which is noted also in the report that plaintiff submitted.
Koopmans, you've addressed a lot the self-insured piece. What about the out-of-state blues and the arrangements with those? And I think Mr. Norris says in his briefing that there's, in effect, a market allocation, that the out-of-state blues have agreed not to come in Iowa, and the Wellmark, or South Dakota Wellmark, agrees not to go in their territories, and that's a horizontal market allocation.
There has been no claim in this case that there is a horizontal market allocation. The stipulation that plaintiffs have agreed to is that their only claim is a per se unlawful price-fixing claim. So essentially what you have here are indeed the out-of-state blues in this joint venture who have, because they do not serve large employer customers in the state of Iowa, they do not have a lot of insured lives. It is not worth it. They do not have the economies of scale to make it worth it to go out and survey all of these doctors to find out what price they're willing to agree to and create their own provider network. So what they've done, what the blues have done, is essentially enter into this cooperative arrangement to create what is a national insurance company that competes with other national insurance companies like Aetna, like United Health. And so I'll just emphasize again, although you do find those stray comments in plaintiff's brief about market allocation, that is not a claim here. In addition, so the blues are just like any other self-funded plan using Wellmark's network. And again, to say that that is per se unlawful would mean that no payer can agree with another payer to enter into a cooperative agreement for a provider network. What we heard from Mr. Norris a lot is that he thinks he has a good rule of reason case. What he talks about a lot is about Wellmark, about specifically his clients, in this case chiropractors, so how Wellmark's market share lines up against the practical realities of chiropractors. None of that matters if this is really just a per se case. 100 self-funded plans who get together and hire a third-party administrator cannot do that if they're doing it even with these conglomerate hospitals, if it is per se unlawful. Mr. Norris talks also about the market shares of Wellmark. The market share that he's referring to, again, this is in the evidence that he submitted, is the market share for insurance. But the market in which Mr. Norris and his plaintiffs have identified as being at issue here is not the market for insurance, but the market for purchase of healthcare services. The report that Mr. Norris cites in his brief states that a significant portion of healthcare services in this state are purchased by very few. So, for example, people on Medicaid and Medicare, that may represent 20% of the insured lives in this state, but that may represent 80% of the healthcare services that are purchased. So so when he says 60%, that is not an accurate figure of the market that would be relevant in this case. Of course, plaintiffs don't even need to define necessarily a relevant market in this case under a per se violation, because there is no analysis of the market share under a per se case. I also just want to make clear, I think the court understands well enough that this is very complex. In the healthcare market, essentially, which is a two-sided market, and you have two separate markets, it's very highly regulated, and any rule that affects how insurance companies and third-party administrators can purchase healthcare services necessarily affects the cost of healthcare and therefore the cost of health insurance premiums. The country has had a national debate about the best way in which to provide healthcare and health insurance for our citizens. That is a very complicated topic, and to use a blunt instrument like the per se rule would be very dangerous. The point...
I would agree. I mean, if Wellmark got together with another health insurer and they just agreed, this is what we're going to pay chiropractors in Iowa, regardless of the complexity of the health insurance market and so forth, that would be a per se violation, right?
Yes, it would. And if you look at the North Jackson case, actually it sets out those two separate claims, because that, Justice Mansfield, would be a naked agreement on price. There's no provider network at issue there. The whole point of sharing a provider network and the price agreement is necessary for that, whereas in the example you're talking about, two insurance companies getting together and just saying, we each have our own provider network, but you charge $80 for a visit and your provider network will do the same in ours, would be a naked restriction with no pro-competitive justifications. And in the North Jackson case, there were those two claims made. The first claim was that there was a horizontal conspiracy of the insureds and self-funded plans that Caremark administered in its network. The second claim, that the court said, was it should be analyzed under the rule of reason, and that is the claim in this case. The second claim is that Caremark, who is the third-party administrator of pharmacy benefits, was just agreeing, as you said, Justice Mansfield, to set the price with other PBMs. There was no other cooperative arrangement. They didn't share claims processing, and Caremark agreed in that case that would indeed be a per se violation, so that claim stayed in. Based on what I know, that was not proven, but if there are no further questions, thank you.
Thank you as well, Counsel. Mr. Norris. Mr. Norris, before you begin, let me throw this question out to you. These arrangements that are at issue here don't really look like the bare price-fixing arrangements, but they seem to be infused with all sorts of issues that are a part of the national debate over health care, as Mr. Koopmans has mentioned. As kind of indicated in that North Jackson pharmacy case, is this really something that courts ought to be weighing in on and making a declaration that they are per se in violation of the antitrust laws?
I don't see that the issue here is all that complex. Certainly, Wellmark does other things for the self-funded, particularly, than just simply read its provider network and an established price for everybody. It does do administrative services and things like that. I want to make clear, I mean, the problem simply as far as our chiropractors are concerned is simply they have no other market to sell in many instances. It is the only game in town. If indeed self-funded in Iowa wanted to establish some sort of a joint buying cooperative and have that administrator do that, and also provide the administrative services and things like that. I'm not here saying that would be a violation of the antitrust laws. I think that there would be positive pro-competitive reasons to do that.
How is that different?
Because Wellmark isn't the same level of Wellmark already has this huge market of its own. It's already got the network. It's already established the prices. What it's doing is it's adding another segment of people that are equally as big.
To me, I mean, it sounds to me like potentially a good argument, but it sounds like a rule of reason argument, doesn't it?
Now, how can it be a rule of reason argument? The rule of reason, there's only two other things that are in I've seen the jury instruction as a rule of reason case. There's only two other things that the jury looks at in a rule of reason case. They look at whether there are anti-competitive aspects of the combination, and then they look at whether or not there are pro-competitive aspects of the product, like it's a new product, like BMI versus CBS, that case, or something of that nature. Okay, those are the two issues, and then they're supposed to weigh them. There isn't a rule of reason established if you don't show that there are some pro-competitive reasons for this combination. Now, the case law that this court is supposed to follow, according to Iowa statute, the federal case law. The federal case law has made that combination that sets price illegal per se since before the rule of reason was established.
I mean, let me ask you another question. Let's say I'm an employer and I'm again looking for health insurance for my employees, doing my annual arrangement, trying to negotiate my annual contract, and I want to go to Wellmark and say, I don't want to buy everything from you. I want to buy your network and your claims administration. You know that business better than me, but I don't want to buy financial risk. And Wellmark says, well, sorry, because of this decision that it's a per se violation, we're going to sell you have to buy all or nothing. I might say, well, wait a minute, that sounds like an unlawful tying arrangement, which is also a violation of the antitrust laws, right? Because
I agree.
I have to buy this one product to get the other.
What you're saying is what really has happened. The employers buy Wellmark's network and its price fixing. That's what they buy, and they get some other services too. That the principle, and Wellmark is saying, well, this doesn't work for self-funded unless they use our network because it's going to be too expensive for them to create their own and do their own administration. Well, I mean, the fact is you get a monopoly profit from any price fixing scheme. You know, you get if you enter into a price fix with your competitors, you can relax. You've got a better deal going here. The issue isn't a better deal for the competitor, in this case the employer, the self-insured employer. Isn't it a better deal for them if they could enter into a price fix? Why, hey, absolutely, it's a better deal for them if they could enter into a price fix. But that's not what the antitrust laws are there for. The antitrust laws are to get more competition. And that's what we're looking for here.
Thank you, counsel.
Thank you.
The case then is submitted. We'll hear the arguments in the next case.